New York labor law 740 is the whistleblower statute, and there was a huge amendment to the law in 2022 that made it much more employee-friendly. You're protected whether you put something in writing or whether you say something verbally to a supervisor that constitutes a whistleblower complaint. You are protected even if you don't get fired necessarily. You could still have protections. It doesn't require that you get fired, doesn't require that you get suspended. It helps the case, of course, to have an adverse employment action, like being demoted, getting put on a performance improvement plan, things of that nature. But what it does is it expands the scope of what constitutes retaliation, number one. It expands the scope of what constitutes blowing the whistle. So you're protected even if you think something reasonably violates public policy. And so there's expansive protections. As long as you have a hunch and you either verbally or write something to a supervisor, then you planted that flag. Poof, you're a whistleblower. You can remain anonymous pre-suit, just like any other employee. If you come to a lawyer and a lawyer contacts your employer or your former employer and says there's some legal issues here, then you're anonymous from the public sphere of a lawsuit being filed to that extent. But if you're going to file a case in court because the case doesn't resolve early, then your name is going to have to be out there.